Good morning, all of you, and welcome from Sukanya and myself to this session. There are quite a lot of you there, I think about 75 going up. So we are going to ask you to put all your questions into the Q&A, and we will deal with it as much as we can at the end, and if necessary, perhaps stay on a bit longer for those who've got the time. We're both members of the charity and social business team at Russell-Cooke, and we both spend most of our time looking at and trying to sort out a whole range of governance issues. But we're part of a broader team which has got property lawyers in, employment lawyers, people who deal with data protection, litigation, commercial contracts, and of course, human resources. And we look after just under 500 charities. And they range right across the size range from very large to just starting up. For those of you who find it useful, we do an email update, and you're welcome to sign up for that. This session will be recorded, but once we get to the question and answers to enable you to ask the more delicate questions, we will not record that. Without more ado, I'll start by looking at our first slide. It really is a very crucial moment when people join a board, and it's crucial from a whole range of reasons. Firstly, there are technical issues, and they need to be properly addressed. So, are people legally eligible to be trustees? And both the individual has to consider that, and the organization needs to check that, and not as many as should do check that there aren't issues that prevent a new trustee joining. But this is also the beginning of making a successful board, and what you've got to try and do is think about how do you build a successful team, and it doesn't happen by accident. You've got to be welcoming, and in an era when we're all trying to create more inclusive and diverse boards, if you're not welcoming, you're not going to retain people who are different from the general run of your existing trustees. So diversity, equality and inclusion begins with the whole onboarding process for trustees. And you need to think, is our onboarding process something that welcomes people and makes them part of the team quite quickly? You may say, why ask whether you're properly appointed? Well, the sad truth is we do quite a lot of governance reviews for people. And I would say that in 15 to 20% of cases, boards have not followed the right procedure for appointing people. And there is some doubt as to whether someone's properly appointed. The Constitution, it's sure you should have a copy of the full Constitution, but your onboarding process should give someone a good summary, and someone should take you through it. The job of a trustee is increasingly governed by Commission guidance, and of that guidance, the very best is the Essential Trustee. It's a very short document, and I think at the very least, every single new trustee should be taking a look at that. And then there needs to be an induction program, and the speed at which you become a valued and useful member of your board, or new board members joining get up to speed, is directly linked to the effort you put into induction. So there are things like somebody telling someone the informal history of the organization. There are routes to good induction, which include things like setting up a buddy system where each new trustee is allocated someone to whom they can talk out of meetings. Board meetings are not good places for getting inducted. In the old days, people did very little of this. It is increasing, but even where people have got quite good induction intentions, they're very frequently not delivered on the ground. And then once you've been through the initial induction, what are you going to do to really get to understand this organization? Very often you talk to trustees. I do many governance reviews and ask them about certain aspects of the charity's activities. which they actually slightly puzzled about. They haven't been to the site where that's occurring. They haven't talked to staff delivering that service. They haven't looked at the sector more broadly in which their charity operates. They don't get sector publications. Their charity may be part of an alliance of similar charities. Do they go to meet people who are trustees of similar charities and understanding the challenges that they face? And do they socialize with the trustees of their own board? Because coming back to my original point about team building and inclusion, you are only going to get a really effective team if you build relationships between trustees, which lead to an open and frank way of dealing with one another, but also a friendly and enjoyable way. We all spend hours and hours at trustee events of one sort or another. We're only going to be willing to carry that on in the long term if we find that an enjoyable and inclusive process. And in all this process, you should be asked to sign up on a code of conduct. And you need to treat seriously the issues such as confidentiality, and someone needs to talk the person through that. In the next slide, what we have here is an attempt by the Charity Commission to encapsulate in one sentence exactly what your job is. So it starts by making clear that you're ultimately responsible. And for many of us, being a trustee means relying on chief executive and a senior staff team to deliver much of what is going on. But we all have to remember that that ultimate responsibility settles with us, and that it is the trustees, not the staff, who are supposed to be setting the broad goals. Now, clearly, for complex operations, you expect the staff team to come to you with strategies. But in order to make those strategies real, you need to think, what are the board processes which will enable you to really take direction of the organization? And to be frank, sometimes board meetings are so filled with the day-to-day, the keeping up to date on a whole multitude of issues, that the overall direction gets lost. And there's a lot of academic research that shows that having away days and periods where the routine business is put aside is absolutely vital to achieving good governance. The ensuring that you're solvent is generally something that most charities are pretty good at. But there are difficult issues which only really get resolved if trustees make them front and center. For example, setting the level of reserves that you're comfortable with may involve difficult decisions about deferring current expenditure or cutting costs. And it's not likely, to be frank, that a staff team is going to come to you and say they need to suffer a certain amount of pain in order to get reserves to a level which is sensible. So the difficult decisions do sit still with trustees. You're supposed to make the organization well run. So that very much is about safeguarding high standards and having an approach which sets the moral tone for the organization. A charity's got to deliver charitable outcomes. And while most things that are a good idea fall sometimes within some of the charitable outcomes, not everything does. And you need to be aware of the limitations of what your charity can do, because no charity can do all good things. And one of the things that the Commission requires you to do is to look as to whether you meet the public benefit test, and they produce guidance on this. And you need to be able to show, if you're ever visited by an enforcement visit by the Commission, that this is being considered by the board. And finally, your objects may be historic. They may reflect what the organization was originally set up for. It's very important that you're aware of any limitations in it, whether they're geographical or particular groups of beneficiaries. And if you're finding that you're butting up against the end of this, your strategic review needs to say, well, given what we're trying to achieve more broadly, we're going to have to move our objects forward. And the Commission is quite good at accepting reasonable changes to objects. Next slide, please. So the Commission, in their document, Essential Trustees, sets out what they see as the key things that you should be doing. And one of the things I like about the Commission's document is that there are a lot of links to other documents, for example, on how to have well-run meetings and how to deal with conflicts of interest. And essentially, this sets out in slightly broader detail what we've just been looking at in that one sentence. There are difficult issues here which are kind of alluded to. So if you see that there is a duty to act in the charity's best interest, some of you here come from organizations which are membership organizations. And that creates all sorts of issues about what is in the charity's interest, what is in the members' interest, and how charitable outcomes can be achieved, even if they're not particularly popular with all members. So one of the things that the guidance is saying is that if you're a trustee who's elected by a subgroup within the charity or a regional group or people with a particular agenda, you have to remember that once you step onto the board, that special interest must step aside for the general interest of the whole of the charity. One of the things that you'll see at the bottom is that you've got to act with reasonable care and skill, and this is reinforced, as Sukanya will say, in directors' duties, is that you need to recruit people who have the skills to deliver the tasks that you have in front of you. And these will vary enormously depending on the size of your organization. But it is not good enough for someone to say, well, I simply don't understand a key element of the responsibilities, perhaps the finances, perhaps something about the delivery. You either have to train the trustee to do that or provide additional support and reports so that there's no doubt that somebody understands all the issues that there are. Sukanya.
Thank you, James. So many of you who are attending today, I know, are also trustees, obviously, of charitable companies. So in addition to those duties which James has just discussed regarding duties under charity law, if you are a trustee of a charitable company, you are registered as being a director at Companies House, and therefore you are also, as an organisation, having duties individually as trustees under the Companies Act. So the key overriding duty for any trustee stroke director of a charitable company is that you must act in a way that you consider in good faith would be most likely to achieve the company's purposes, i.e. the objects of the charity, the whole reason why you've been set up, for example, to relieve poverty or to advance education. Whereas for a commercial company, it's the overriding duty under company laws to promote the success of the company for the benefit of its shareholders as a whole. Next slide, please, Rachel. In addition to that overriding duty, there are a number of other duties that you have under company law, particularly in relation to acting within your powers. Now, this is very similar to the charity law duty, fundamentally ensuring that any activities that your organisation undertakes fall within your charitable objects and the powers. And the powers are normally set out just beneath your objects, saying, for example, you can enter into contracts, you can employ members of staff, you can enter into security arrangements, etc. And you must always ensure that whatever you're doing is not only charitable, but it obviously falls within the charitable objects itself. To the extent you go beyond your powers, referred to as being ultra vires acts, then potentially you could be found that you're personally liable for any financial loss to the organisation, although circumstances of that happening are generally very rare in the charity world. You do, as a director, also have a duty to exercise independent judgment. This means, not being faced by and submitting to potentially an overbearing personality on your board or a particular chair, and ensuring that once you make a decision as a board, that you move forward collectively on that decision, even if you may not be happy with the decision that has been made. If you feel very strongly, potentially you could ask for the minutes to refer to the fact that you had strong reservations about that decision. But once a decision is made, move forward together as a board and carry through that relevant decision. As James mentioned, you also have this concept of reasonable care, skill and diligence. Now, this is both an objective test and subjective. It's objective in the sense that you have to have a reasonable level of skill and care one would expect as somebody undertaking your role in an organisation of your size, but it's also subjective. So if in your day job, you're the finance director of a company listed on the stock exchange, you'd be expected to have a higher level of financial skill in that area than the average person. And the final three duties set out there are all very interlinked, and they're all about avoiding conflicts of interest and, for example, not accepting a benefit, be it financial or otherwise, from a third party for either doing something or not doing something. And this whole concept of conflicts of interest is something which James is going to elaborate on a bit more later, but it's an area where the Charity Commission is very hot on making sure that trustees, be you of a charitable company or otherwise, are ensuring that you are dealing appropriately with conflicts of interest. Good, next slide. So the Charity Commission, for any organisation that's registered with as a registered charity, you're obviously regulated by the Charity Commission. And what we've seen, and particularly over the last 2 to 3 years, an increasing stance of the Charity Commission acting much more as a regulator as opposed to a champion of charities. In particular, their 5-year strategy from 2018 to 2023, two of their key areas and objectives are to hold charities to account and to deal with wrongdoing and harm. The chief exec has said that, charities should be held to a higher standard of behaviour, conduct and integrity. And a lot of this stems out from, many household names who have recently found themselves in difficulty and potentially, you've seen it obviously in the press, particularly social media is a big issue for a number of organisations now. And we saw the aftermath of the Oxfam, where there was a statutory inquiry following the Haiti earthquake back in 2010. And following that, it found that the Charity Commission found that the Oxfam had been potentially covering up the use of sex workers and the exploitation of sex workers in Haiti by aid workers of Oxfam. As a result, obviously, public confidence was knocked for the charity itself, but also more generally in the sector. And the Charity Commission is very keen that if it sees any media attention or potentially political interest regarding any particular charities, that it may, if there's negative press about them, intervene and potentially could open an inquiry. Recently, particularly over this summer, we saw what happened with Barnardo's. Many of you might have seen that. It was basically a blog post was put out where it talked about racial prejudice and white privilege. As a result, there are a number of Tory backbenchers who refer to themselves as the Common Sense Group made complaints to the Charity Commission about this, saying that the charity was not acting appropriately and not acting within its charitable objects. However, Barnardo's was exonerated by the Charity Commission, but it just goes to show that if people do make complaints to the Commission, that it can have an effect, not only for that particular charity, but more generally. And this links to this concept of serious incidents, which I'll be elaborating on later. But the Charity Commission is very much promoting the fact that charities should be reporting any incidents that take place, that they are seen as being serious and should be reported to the Charity Commission. And this can be anything from potentially a fraud attack on your organisation, cyber attack, or, for example, if you find that there's been theft within your organisation or you lose a particular contract of value to your organisation, it should be reported to the Charity Commission. And we'll look at that in a bit more detail in a moment. So there's active regulation of you as a registered charity, and the way the Charity Commission goes about this is by producing the guidance. And we referred to the some of the key guidance that we're talking about today on the last slide. So you'll get a copy of this presentation following this webinar. And in the guidance from the Charity Commission, it is extremely helpful. They set out what you should be doing as in recommended practice, and also what you must be doing within the guidance to ensure that you're adhering to your relevant duties. We have seen a bit of a shift with the Commission that potentially there's more emphasis on following through even with the shoulds in the recommended practice to avoid being potentially seen as not acting as breach of your relevant duties. Obviously, you report back to the Charity Commission. You have to file your annual report and accounts to the Charity Commission, and also return your annual return to the Commission. Obviously, if you're registered also with Companies House, you should be submitting a relevant return and your reports to Companies House as well. Ways in which a charity commission can get involved with your organisation if they think that there might be some regulatory issues is potentially by issuing a warning. And a warning is generally where you get a letter from the commission where it says that they're concerned about a particular matter. It may be that the potential might be a breach of duty, or because somebody may have raised a complaint, and that they then work with you as a charity to try and resolve that issue. And that would obviously be acting together with the board. If, however, you fail to adhere to that warning, or if the issue is so serious that they believe that public assurance needs to be made, then they can go straight to opening what they refer to as a statutory inquiry. And if you look on the Charity Commission website, almost daily they are putting out there that they have opened a new inquiry in relation to a charity, potentially for mismanagement or misconduct. And then they will go on to report that put out the final report in relation to that statutory inquiry once they've completed that. And again, we've seen household names such as National Trust, which I'll be looking at later, which ended up having a statutory inquiry opened on it following, again, complaints made by various backbenchers and this group referred to as Reform Trust. So the Charity Commission is keen to know if there are any issues within your charity, or potentially where any harm might be caused to any beneficiaries or to staff members or even to trustees, or as a result of reputation to the organisation. And they do have now a whistleblowing form and contact that you can use on their website if you want to make a whistleblowing statement to the Commission, and they will then look into the issue, see if anything needs to be done, and then potentially liaise with the charity itself. The other extreme is also that they can do compliance visits. Despite their cutbacks, the Charity Commission has been more recently saying that it will take a proactive approach and potentially can ask to say to a charity that they're coming to visit you virtually or otherwise, and could you provide them with relevant governance policies prior to their meeting. And we've had one or two clients who have been subjected to one of these compliance visits and needed to provide all the relevant paperwork prior to the meeting. At the very extreme, they can obviously remove trustees if they believe there has been misconduct or mismanagement within the organisation, and they can even intervene by putting in interim trustees. And at the very extreme, they can obviously close the charity if they think it's no longer appropriate for that organisation to continue. Next slide, please, Rachel. So in this changing regulatory climate, the real focus from the Commission, their key priorities at the moment seem to be on focusing on ensuring trustee compliance with those duties which James and I have discussed. There's also this particular focus on any issues relating to not only the reputation of your charity, but the sector as a whole. And they will see anything that potentially could affect the reputation of the sector or even of the Charity Commission as being something that they will need to get themselves involved with. I mentioned this increasing importance of following the guidance. In addition to that, we've also seen the Charity Commission can issue regulatory alerts. Some of you will be aware of one of the main alerts they issued in June last year, and that was following their statutory inquiry into a household name, RNIB, Royal National Institute of Blind People, following the closure of the Pears Centre. Now, the Pears Centre was both a children's home and also a school for visually impaired children. And unfortunately, what the Charity Commission found was that there were serious governance issues in relation to that centre, and also more worryingly, safeguarding concerns regarding potentially incorrect medication being given or not being recorded appropriately. As a result, the Commission took the unusual step of not only issuing the report for following the inquiry, which was on their website, but also it issued this alert, which went out to 600 charities with over a 9 million income, so the very large-scale charities, where they have a separate board from their senior management team and where they're providing frontline services. And basically, this alert was identifying that organisations really need to ensure that they are dealing with safeguarding concerns, and we'll be looking at that later, as well as making sure that they are following their trustees' duties and being accountable. What they said in relation to the RNIB alert, in this particular scenario, that there was over-delegation to a committee, particularly in relation to safeguarding, which was inappropriate and wholly ineffective. And they also said that certain members of staff were not qualified to carry out their roles. So the alert is really important. If you haven't read it, I would suggest you do read it. It's some useful bits of information in there, but primarily the Commission talking about accountability of boards. There has also been a particular amount of controversy regarding a number of household name charities. I mentioned Bernardo's. More recently, obviously, we had National Trust. The National Trust found itself in a lot of difficulties following its report, which said that of 93 of its places of historic interest and places to visit had potentially been funded on the back of colonialism and the slave trade. As a result, this Reform Trust, which consists of ex-members of National Trust and potentially current members, as well as some Tory backbenchers, complained to the Charity Commission and said that National Trust was following a woke agenda and should stick to what it should be doing. Luckily, the Charity Commission did exonerate the National Trust in relation to this and said that they hadn't acted in breach of their objects, and that the organisation had acted appropriately, even though what it might be doing might be seen as being controversial by certain groups of individuals. You will note that the Charity Commission is about to appoint, or has appointed but not yet named, the new chair of the Charity Commission. Again, the former Culture Secretary got involved in saying that whoever was appointed should be tested on whether they're going to ensure that charities don't follow what he referred to as being a woke agenda. So it's interesting to see who eventually will actually be appointed. And if James is just going to talk about some of the other particular concerns.
Okay, so what you're getting a picture of from Sukanya and I is a Charity Commission which is much more activist and showing that activism both by launching inquiries, and Sukanya mentioned inquiries, but they've literally increased tenfold over the last 4 or 5 years. And that activism is focused on what they say here, i.e. holding trustees to a higher standard. And the reason that they say they need to hold trustees to a higher standard is that they believe that their duty is to support the public interest, and they believe that their research shows that the public would like trustees to be held to a higher standard. Now, as a lawyer, that causes me significant difficulties because, you know, what is a higher standard? Are we supposed as charities to be held to a higher standard than the police force or the government or the NHS or schools? And the other fundamental issue is that charities are there to deliver public benefit. And what the Commission seems to have morphed into believing is that charities should be there to put the public interest front and center. And the public interest is not a concept that I'm happy with or comfortable with. It changes. And the public interest is represented in the media by very conflicting views. And the sector as a whole is so broad that the idea that there is a similar public interest in the behavior of a religious order or an international aid agency or an old people's home causes me difficulties. And what we had, as you all know, was a major insolvency at Kids Company. And that charity closed as a result of its funding being withdrawn, as a result of allegations made against it, which later turned out to be false, but it lost its money and it became insolvent. And following that, the Insolvency Service decided to take the trustees to court along with the chief executive for failing to manage the property at the charity properly. And this is an absolutely landmark case and provides trustees, I think, with a huge amount of reassurance, because what Mrs. Justice Falk said throughout was that, in her view, the trustees were not people who the public needed to be protected from. They were people who had done their best in a difficult and financially unstable situation. And here is the sort of one of the key quotes from her is that, you know, the law looks benevolently on trustees where there is evidence of acts or potential acts of breach of duty. The law recognizes what a difficult job you've got. And in this attempt by the Insolvency Service to disqualify the trustees, Mrs. Justice Falk threw out everything that the Insolvency Service had requested and said that the trustees had acted fairly and reasonably and they were not in any way to blame. So we do have this conflict between what I might call a more traditional view of what a trustee has to do, represented by the courts, and this developing view of the Charity Commission that the public interest is what trustees should be serving, and the difficulty of understanding of what the public interest is in any particular issue. So this is something where I think you'll see continued developments, as there has been something of a politicization of the Commission and the way it operates. So as trustees, you're responsible not just for clearly meeting the requirements of the Charity Commission and the Insolvency Service and your duties under Companies Act, but a huge range of other things. And you need to find mechanisms for giving yourself reassurance that these things are being dealt with properly. Some areas have become more problematic than they used to be. So, for example, fundraising. The Commission feels that for many years, trustees allowed fundraising to go on without much review at a board level. You do need to know exactly how fundraising is being done in your name and feel comfortable that it's being done in an appropriate way. The Information Commissioner who runs data protection used to be entirely benevolent towards charities, and one could barely find a case in which he or she had intervened. More recently, following GDPR and the changes in data protection, they have been much more activist. And so you need to be sure that your organization has had either good data review internally or used external people to make sure that you are handling data in a compliant and correct way. And do be aware that having done all that work for GDPR, further work needs to be done now following Brexit, because while those roles are broadly similar, they change. Safeguarding, we're going to look at this in a bit more detail, but the key thing to remember about safeguarding is that it used to be that people thought of safeguarding in line with its legal definition, which is protecting people who are vulnerable because of age or infirmity. The Commission takes the view that safeguarding involves looking after anyone who comes in contact with your charity. And that means that things such as complaints procedures are absolutely vital. Health and safety, not a big cause of problems, but do remember that you as trustees have a potential personal liability if there are breaches in personal and safety. So you need to be sure that you've got the sorts of processes in place, and if necessary, external support to leave you reassured that these are being dealt with properly. And finally, yes, as a charity, you've got various tax benefits, but it doesn't mean you're outside the network of tax. And we've had a number of occasions where charities have not really been fully aware of the implications of VAT for themselves and have got into serious trouble and faced large claims. So what you need to have, I think, is an approach really, which is a heads up, a really curious understanding of what your charity is doing, and a sensitivity to the areas where you don't understand the area very well, and get advice to be sure that you're complying, because that's exactly what happened to RNID. The people on the committee didn't understand it, the staff didn't understand it, and no one drilled down to discover the level of severity of the problem. Next slide, please. Now, we've been talking about the regulators. The Charity Commission did think about creating a charity code, but while it was doing so, a group of larger charitable organisations got together and produced the Charity Governance Code. And we're now dealing with the third revision of that governance code, which has changed it quite considerably. And it's a very useful tool for all boards to use. It's in two versions, one for larger charities and one for small charities, larger being over £1 million. And it sets out what it thinks you as trustees trying to achieve good governance should be focusing on. And one of the ways it does that is by encouraging you to have internal reviews each year as to how well you're doing in terms of achieving the goals in the code, and also every 3 years undertaking a review of your governance, which is done by someone externally. And I spend a lot of my time now doing these triennial reviews, and they do help boards focus on the gaps and issues and areas where they need development. So currently, this third edition of the code placed particular emphasis on boards being much more systematic about equality, diversity, and inclusion. Most boards have aspirations to be more equal and diverse and to include a wide range of people, but their achievement is quite patchy, and also their monitoring of their own achievement beyond their good intentions may not stand up to much scrutiny. So what the code is now saying is that you should have a strategy for dealing with these issues, that you should have training that supports it, that you should have goals which you're working towards, and that you should monitor your achievement of those goals. So what everyone is looking for is a more systematic approach to governance, and the code provides a framework within which to do that systematic approach. So integrity, again, an area where the code has made considerable change. Sukanya alluded to the fact that there are quite a lot of boards where power is unfortunately differentially allocated, where an individual or a group of individuals dominates a board, and you don't have genuine collective discussion and inclusive decision making. You have effectively an individual, perhaps a chief executive or a chair, setting the agenda of the organization in a way which doesn't relate to the duty as a board to act collectively and to make decisions as a group. Do remember that both company law and charity law don't give a chair or a vice chair any special powers unless you pass them to it. Yes, the code recognizes that in order for a board to function well, you need leadership from a chair. And it also recognizes that sometimes a chair needs someone to tap them on the shoulder and say that perhaps their leadership is a bit too strong. And that's one of the roles often handed to a vice chair or senior non-executive. So using the code with both with an internal annual review and an external 3-yearly review is a good way of doing a health check on yourself and developing your own work. But behind this does come something which is sometimes at odds with any board of trustees, is that they're keen to see the money that they look after spent on their beneficiaries. And maintaining good governance isn't entirely free. You're going to have to put time, effort, and money into good governance, but it is worth it in terms of the quality of output of your charity. Could I just also draw your attention to another approach to good governance, and that is thinking about what you as a board member do when you're actually at a board, i.e. the behaviors you display. And I think that Julia Unwin has really well encapsulated it by saying there are really 5 behaviors that really one would hope to see. Firstly, as trustees, you've got to be supportive, to encourage, to celebrate. Very often staff are doing great things with limited resources and needs some sort of support and encouragement. Secondly, you are the stewards, both of the money, the reputation, and the safeguarding. You must be clear about the strategy. You need to be setting that strategy in a good way. And you also need perhaps sometimes to stretch. There are organizations who have delivered the same output year on year, and that may be good, or it may reflect a failure by trustees to actually say, well, couldn't we do more? Couldn't we do better? And finally, people will come to you with suggestions, reports, and accounts, and you've really got to scrutinize these and kick the tires. And if you aren't able to do so, you may need to get external advice on those issues. Next slide, please. So conflict of interest. About 1/3 of the Charity Commission's interventions in charities are linked to conflicts of interest or conflicts of loyalty. And it's important to remember that the guidance about managing these is guidance about managing something which isn't fundamentally bad, one would expect to see conflicts of loyalty in a charity board of trustees, because you will probably recruit people with an interest in the area in which you're working. They may have dependents, they may have membership of other charities doing work in the same sector. There are a whole range of reasons why you may have a conflict of loyalty. But what is important is that they're managed properly, and there's good guidance in the Commission website. And what is key is that you think not only of actual conflicts, but of things that might appear to a third party to affect your decision making. And there's some basic quick rules. Declare everything. And here I've put a list of people whose interest you ought to declare as well. You know, I have a daughter and a stepdaughter. They both work in the sector. I have to declare what they're doing because that might affect my judgment as a chair of a charity. Then you have to record that in a register of interest. That register of interest has to be disclosed to the whole board. Still quite a lot of boards where registers of interest are shared with the chair only. That's not really satisfactory. Then you have to decide how to manage those interests. And they may be trivial, and the board may say, it requires no steps at all. Thank you for telling us, but they're not relevant. Or it may be very serious, and the person may need to leave the room every time the issue is discussed, not vote, and perhaps not even receive the papers. Then you have to decide, when you've decided how you're going to do it, you actually have to implement that process, and you have to minute it and record the actions you've taken. And you then occasionally should review, are we actually doing what our conflict of interest policy tells us we should be doing? Next slide, please.
Thank you, James. So James mentioned there about safeguarding, and as we've seen with the Charity Commission, they've increased what they consider to be the areas of safeguarding. So it used to be about protecting children and vulnerable adults, but now it's seen as being protecting anybody who comes into contact with your organisation. So that can be a member of the public, volunteers and beneficiaries, members of staff as well. And safeguarding is much broader now in what potentially it could cover. So it's all of these particular items set out here. So, for example, sexual harassment, negligent treatment, bullying or harassment, and any form of discrimination on the grounds of the Equality Act. Bullying and harassment has been something which has very much been seen in social media and the press. Even large-scale charities such as National Council for Voluntary Organisations. Just this year, there was an independent report that found that there was large-scale bullying and harassment within the organisation occurring at all levels on grounds of race, and gender and disability. So real issues for organisations, and also reputation of the organisation going forward and the sector as a whole. Next slide, please. So how do you ensure that you are managing safeguarding? Now, the Charity Commission has said that safeguarding should be one of the priorities of all charities, particularly after the RNIB alert that they issued. James mentioned the complaints policy. This is something which the Charity Commission is very keen on having, that a charity has a very clear policy. So a member of public, for example, if they want to raise a complaint against the charity, they know who to contact, how to contact them, and when they'll hear back from the charity. And that policy, ideally, if you have a website, it should be easily identifiable on your website, often near the contact information, so that somebody can raise a complaint if they wish to. You should also ensure that as a board, you consider what your safeguarding procedures are. For example, do you have a safeguarding policy setting out how you're going to protect individuals? That policy may well refer to other policies that you have, such as your whistleblowing policy or your anti-bullying policy. But it's important to have a separate safeguarding policy that, again, should be available on your website and easily attainable for anybody who comes into contact with your organisation. We often carry out a number of reviews of safeguarding policies for clients, and in particular, there's been an increase in this whistleblowing, and whistleblowing not only to the Charity Commission, which has increased over 34% over 2019-2020, but also ensuring that you have a whistleblowing policy within your organisation as a whole. The whole aim of that is that if there are any issues within your organisation, potentially where there might be harm to beneficiaries or to members of staff or to the assets of the organisation, that an individual can report it internally, and that then it will be followed through and it will be potentially investigated to see what needs to be done, if anything, and how to prevent it from happening again. There's very much interest of the charity to ensure that you have what we call a speak up culture, so that any near misses are reported to the board, so that potentially you can learn from mistakes that could have happened or that might actually happen in the future and try to avoid them. You also need to obviously be careful about who you recruit and who you select. For example, making sure that if people say they have relevant qualifications to undertake particular activities within your charity, that you've checked relevant references at least, and that if there are any major gaps within their CV, that those have been checked as to potentially why they have that, as well as checking whether trustees, for example, they're not disqualified from acting, and that you've done those relevant checks that James mentioned at the beginning. Do also consider whether you should have exit procedures, a very simple exit interview when, say, a trustee leaves the board or when members of staff leave your organisation. You may find that that's quite helpful in identifying if there are any particular issues within the organisation or a particular department. Earlier this year, St John's Ambulance reported that it had paid over 1 million in severance payments to 15 members of staff as a result of claims of bullying and harassment. And you kind of wonder if maybe there had been exit interviews, whether it may have come to light that there were particular issues within a particular area of the organisation, bearing in mind that they were found to have paid out this significant sum of money when at the same time they launched an appeal during COVID to raise 6 million to keep the organisation from going under. So it can obviously have a real knock-on effect for those involved with the organisation. Linked to safeguarding is this concept also of serious incident reporting. Now, serious incident reporting, as I mentioned, is not just in relation to safeguarding, but there have been increased reports of safeguarding issues reported to the Commission. But serious incident reporting is much wider. It's an adverse event, actual alleged, which results in harm or potentially risks significant harm to your charity's beneficiaries, staff, or volunteers, or loss of your charity's money or assets, or damage to your charity's property. So, for example, if you've even had flood damage at your organisation or one of your warehouses, or whether you've had a fraudulent attack on your organisation, or hacking of your computers, or anything that might harm your charity's work or reputation. Now, serious incident reports should not be seen as being a negative. It shows to the Commission that you as a board are considering whether anything has happened within your organisation that should be reported to them. It's a way of the Charity Commission being able to ensure public confidence in your charity and the sector as a whole. We often get involved in assisting clients in submitting serious incident reports. Some submit many more than others. For example, I work with a charity that acts for the rehabilitation of offenders. They run a number of hostels. Those hostels have a lot of individuals who have mental health issues and drug dependency issues. And obviously, a scenario like that, they might have more issues of potentially harm by one beneficiary against another than, say, a simple trust charity that is giving funds to other charities. So they report more regularly, sometimes on a monthly basis, to the Charity Commission. But when you do report, you need to consider what it is. For example, we've acted where a charity had its bank account frozen for due to an error by the relevant bank, and obviously we had to report that. We had a loss of personal data as a result of a courier company that was being used to appropriately transfer certain paperwork, and their courier van got broken into. That needed to be reported also to the ICO, the Information Commissioner's Office, as well as a serious incident report to the Charity Commission. Fundamentally, the Charity Commission considers that where you're reporting a non-regulatory report or non-standard report to, for example, HMRC or to another body such as Ofsted or the Care Quality Commission, you should always be considering whether it should also be submitted as a serious incident report to the Commission. Similarly, like a theft, obviously report that for action fraud or to the police, but also report it also online to the Charity Commission. What may be significant to your charity may not be significant to another. So for a loss of financial loss, for example, of £10,000 may not be significant to your charity, but for another charity, it could mean that they may face closure in the following year. So always consider in the context of your own staff, operations, finance, and the reputation of your charity. Next slide, please. it's very important when you also consider safeguarding whether not only you deal with the issue within the organisation, but whether it also needs to be reported to the Charity Commission as a serious incident report. And the Charity Commission guidance, which I've referred to at the end of the slides, that's really helpful in giving good examples of what they consider should be reported as a serious incident and what they think may not be necessary for you to report. It is vital, however, that as a charity, you do have a serious incident reporting policy. If you don't have a policy in place, then your staff members, as well as you as trustees, will be unaware about how you go about either considering whether something is a serious incident report and should be reported to the Commission, or are you going to look at it, consider it doesn't need to be reported, but at least make relevant board minutes to ensure that you have some relevant evidence that you can show to the Commission as to the reason why you took the decision that you did. Do bear in mind there is a responsibility of the trustees when you submit your annual return each year that you do sign the declaration, which fundamentally says that you're not aware of any serious incident reports which have not been reported to the Charity Commission during the year that's just taken place. So if you don't have a policy, do ensure that you get a policy and that you adhere to it, and that relevant people, not only the board, but senior members of staff, are aware of the need to make relevant reports and people know who they should contact in doing so. James.
Right. Well, I'm sorry that we should have to point out, a range of issues which can seem daunting at times, but I think one should remember that fundamentally a trustee's job is a rewarding and it's a safe job. There are things one has to bear in mind, and we are moving into a situation in which your regulator is much more politically driven and much more focused on concerns from the media and other issues, and that does lead to behaviours, but they affect only a minority of charities. If you act within your objects with prudence, without any personal benefit, and taking advice where you need to, the risks are absolutely tiny. And I think the great thing about the judgment of Kids Company was to emphasise how unkeen the law is to penalise trustees. You do need to manage risk, however, and what you're doing this partly by staying abreast of issues like this. Insurance is obviously vital. Insurance is a bit deceptive. Very often I've been to boards and said, here are some issues for you to consider, and been told, oh, we don't need to worry about those. We've got trustee liability insurance. If you pull out the trustee liability insurance and look at it, things it covers are very, very modest generally. So I do urge board members to actively review what their insurance covers and to decide whether it covers all the things that they would feel responsible for. So there are things, for example, outside your legal responsibilities, for example, theft from staff, which you might or might not wish to cover. So we've put some details of material here. We've now got an opportunity for questions and answers. And thank you all for joining us today. And if you don't get a chance to have your question answered, or you have something which you'd prefer not to raise in an open meeting, do phone or email Sukanya or myself, and we'd be very pleased to talk to you about it.